All right, it appears that everyone is with us now. And so let me call the case and make the announcements required, and then I'll call for announcements from the parties. I call cause number 10,830. The case is styled the State of Texas versus Marcus Joe Villarreal. This is a plea hearing based upon a plea bargain agreement that exists between defense and state, or so the court has been informed. This hearing is being conducted by remote video teleconferencing technology using the Zoom protocol, and it is being live streamed on the court's YouTube channel in order to comply with Office of Court Administration directives, as well as Supreme Court orders requiring remote video teleconferencing hearings and providing access to the public to the courts. Because of those electronic means of conducting this hearing, the court expressly announces that all parties are prohibited from recording this proceeding in any fashion, by any means, electronic or otherwise, except for the court reporter who is transcribing this proceeding by direction of the court, and is doing so just as if this proceeding was being conducted in person, which it is not. The court reporter is participating also by the Zoom protocol. With those pronouncements being made, I first recognize State's Counsel. Is the state ready to proceed?
State's ready, Your Honor.
And Mrs. Wolf, on behalf of the defense, is the defense ready to proceed?
Ready to proceed, Your Honor.
And you are, and let me ask it instead of telling, are you Marcus Joe Villarreal?
Yes, sir.
Mr. Villarreal, you are you located at a laptop here in the courthouse that has been provided for you to use so that you too could participate in this remote video teleconferencing hearing?
I am, Your Honor.
All right, sir. Mr. Villarreal, you have the right to have someone read the indictment in your case and to read it out loud to you here in open court or in Zoom hearing court. Do you wish to have someone read the indictment out loud to you?
No, sir.
Do you understand that it charges you with a state jail felony offense of possession of a controlled substance?
I do, Your Honor.
Understanding that charge, to that charge, how do you wish to plead, guilty or not guilty?
I plead guilty.
And do you understand that you do not have to plead guilty? You have the absolute right to enter a plea of not guilty, and further, you have the right to have it or to not have it used against you just because you might exercise your right. Do you understand that?
Yes, sir, I do.
You also have the right to have a minimum of 10 days notice of the charges pending against you. From the court's own recollection and from looking at the docket sheet in your case, I know that you have had more than 10 days notice. However, we would grant you some additional time if you wish to have it. For instance, we have a jury scheduled to convene next week, and so we would grant you some additional time if you wish to have it. And right now, that jury trial is going to be a different case than yours, but you would have some additional time if you want it, and I would grant that to you. You also have the right to have a jury hear your case, and that's true even if you enter a plea of guilty, as you just announced you wish to do. And yet, I have been handed a document entitled Waiver of Defendant. It has a signature that reads Marcus Villarreal, as well as that of your attorney. Did you sign that waiver of defendant document?
Yes, sir, I did.
And did you realize that when you signed it, that it said you were giving up the opportunity to have more time and you were giving up the right to a jury trial, which meant I was going to hear your case today without a jury. Did you realize that?
Yes, sir.
And is that what you still wish to do?
Yes, sir.
Ms. Wolf, your signature is also on this document. Does that indicate you're joining your client in these waivers?
Yes, Your Honor.
Mr. Smith, your signature is likewise on the document. Is that evidencing the state's joinder in the waiver of the right to a jury trial?
Yes, Your Honor.
All right, I announce that I will accept those waivers and do so by signing the document. And thus, we will proceed to other matters. There are other rights and admonitions I need to discuss with you, Mr. Villarreal. And so let's start by talking about the range of penalties that exist for a state jail felony such as is charged in this indictment. The range of penalties for a state jail felony runs from 180 days up to 2 years in a state jail facility. It also carries the possibility that a fine could be imposed, and if imposed, in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face under this charge?
Yes, sir, I do.
I'm aware, as I mentioned earlier, that there is a plea bargain agreement. I do not have to follow the plea bargain agreement, but I do have to tell you if I'm going to follow the agreement. Because if I should decide not to follow the plea agreement, the law would give you the right to take back your plea of guilty. Stated another way, if I don't follow your plea agreement, you don't have to go through with the plea of guilty. Do you understand that?
Yes, sir.
But there is another side to that coin. The other side is this: if I do follow your plea agreement, then you will be bound by the terms of the plea agreement, and you will not be able to get out of those terms just because you didn't like them anymore. You couldn't get out of the terms even by appealing them. Um, and that's contrary to the norm. The norm is that a person has the right to appeal even from a plea bargain agreement. But the exception to that says if a person enters into a plea agreement and one of the provisions of the plea agreement says that they are giving up the right to appeal, that provision means what it says. And since it's in the plea agreement, you could not appeal at all. Do you understand? First of all, do you understand that that provision is marked in your plea agreement? I've looked at it. It says you're giving up the right to appeal as a part of this agreement. Did you realize that?
Yes, sir.
And so do you understand that if I follow your plea agreement, that provision means what it says and you cannot appeal?
Yes, sir, I understand.
Now let's go further with your plea discussion. And I will tell you, I will ask you some questions I'm required by law and statute and court decisions to ask. The first one is, are you a citizen of the United States of America?
Yes, sir.
Where were you born?
In Big Spring, Texas.
All right, sir. Next, the question is, do you consider yourself presently, that is at this time, to be mentally competent?
Yes, sir, I do.
Do you know what's going on in these proceedings?
Yes, sir, I do.
Have you been able to understand the charges so that you could discuss those charges with your attorney and discuss the facts that surround the charges, thus assisting or cooperating with her in the preparation of a defense in these matters? Have you been able to do that?
Yes, sir, I have.
And have you been able to receive, not only hear, but receive and understand her advice about the law and how the law might affect or be affected by the facts of your case?
Yes, sir.
Mrs. Wolf, do you believe your client is mentally competent?
I do, Your Honor.
I accept that representation. The court has seen Mr. Villarreal in person before the Supreme Court limited our hearings, and has been able to discuss this matter today in the Zoom hearing, observe Mr. Villarreal and his answers. And it's obvious to the court that Mr. Villarreal is mentally competent. And so make that finding as well. Mr. Villarreal, my next question asks, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, I am, Your Honor.
And I think you know why I asked that question, but just in case, let me tell you that I asked that question not because I think you wouldn't be or shouldn't be satisfied with your attorney's work, but I asked that question just so you would have the opportunity to tell me if you were not satisfied, and if it was based upon deficiency or ineffectiveness of the lawyer's work, I could do something to try to get that issue or problem resolved. Uh, but since I have the authority to do that, and I'm giving you the chance to let me know so that we could correct or resolve any problems that might exist, I need to tell you that that also means that you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job, since I give you that chance now. Do you understand that?
Yes, sir, I do.
And understanding that, are you still telling me you're satisfied with the legal representation your attorney has provided to you in these matters?
Yes, Your Honor. I'm very satisfied.
All right, sir. Those are all the questions I have at this time. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
Defense?
No objection.
All right, Mr. Villarreal, let me talk to you about the stipulation of evidence that the state has offered. It also has your signature on it. But there are other rights and admonitions that surround the stipulation of evidence, may be the best way to say it. And so let me discuss some of those with you at this time. First, the state is required to produce some evidence tending to show your guilt. That's true, even though you were entering a plea of guilty, because that obligation on the state's part goes to ensure that another right that belongs to you is in fact carried out and provided to you. That other right is your right. The legal expression is to confront the witnesses against you. And it just means the state has to bring those witnesses into court, have them testify under oath so that you can see them and hear them while they testify. But this stipulation of evidence says you're giving up that right, the right to confront the witnesses, and instead you're telling the state they don't have to bring those witnesses into court at all. Did you realize you were giving up that right to see and hear the witnesses? We call that the right to confront the witnesses when you signed the stipulation of evidence.
Yes, I did, Your Honor.
The stipulation also says that you are giving up your right to remain silent and your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself because the stipulation, as it says, is a judicial confession that wherein you admit that all of the acts or all of the allegations in the indictment are true, that you committed the offense of possession of a controlled substance in an amount that would make it a state jail felony. Did you realize that's what it said when you signed the stipulation?
Yes, sir, I did.
Now, there's another paragraph in the stipulation. As I look at it, it says that you are aware that you owe court costs in the amount of $290, that there's restitution to be ordered in the sum of $180, as well as reimbursement fees totaling $675. Those fees will reimburse the county for expenses or legal fees paid by the county for your court-appointed attorney. Did you realize that paragraph was in the stipulation when you signed it?
Yes, sir, I did.
All right, State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this cause.
State rests, Your Honor.
Defense rests, Your Honor.
State closes.
Defense closes.
All right, Mr. Villarreal, evidence having been presented and then both sides closed, let me talk to you briefly, or as expansively as may be needed, about the plea bargain agreement. I just want to make sure I understand it the same way you understand it. As I read the plea bargain agreement, it says that you will plead guilty to this charge as you have done. It says that that's going to result in a 2-year sentence to state jail, which would be probated for a period of 5 years, that a fine would be assessed in the sum of $1,500. You would pay court costs in the sum of $290, and as well as paying reimbursement fees in the sum of $675. The plea agreement also says you would pay the $180 restitution, as the stipulation said. It says you'll waive your right to appeal, as we have already discussed. It says while on probation, you will participate in what we call the TAP program. And then based upon 2 other documents that have been handed to me, it's my understanding that actions in cause number 10,497 and 10,498 would be dismissed as a part of the plea agreement themselves. I'm not positive because I don't have those files in front of me, but I think those are motions to revoke other cases where you're on probation. Let me ask the state, is that correct?
No, Judge, those are pending indictments from 2017, I believe.
Okay. All right. So those are indictments that have not been disposed of, but they're older cases. Is that right?
That's right, Your Honor.
Okay. And is it correct that the plea agreement includes those cases being dismissed as a part of this plea agreement?
Yes, Your Honor.
All right. Mr. Villarreal, that's my understanding. All of that is my understanding of the plea agreement in this case, 10,830, which includes those other 2 I've been talking about. Is that your understanding of the plea bargain agreement?
Yes, sir, it is.
And are you asking me to approve this plea bargain agreement?
Yes, Your Honor, I am.
Mrs. Wolf, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
And Mr. Smith, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
All right, Mr. Villarreal, I announce that I will accept and follow your plea agreement. And so let me announce that in cause number 10,830, style the state of Texas versus Marcus Joe Villarreal, based upon your plea of guilty and based upon the evidence stipulated to in this cause, I hereby find that you are guilty of the offense of possession of a controlled substance as alleged in the indictment, that it is a state jail felony as alleged in the indictment. That pronouncement being made, do you know of any legal reason why sentence should not be pronounced at this time?
No, sir, I don't.
Then I will do that. And so I announce that in cause number 10,830, the state of Texas versus Marcus Joe Villarreal, for purposes of sentencing based upon your plea bargain agreement, following it, as I said I would do, I hereby sentence you to serve 2 years confinement in the Texas Department of Criminal Justice, the State Jail Division. But also following your plea agreement, I suspend the imposition of confinement and instead place you on probation for a period of 5 years, provided you follow all the rules of probation. And I'll discuss that with you in more detail in just a moment. I also assess a fine of $1,500 in order you to pay court costs in the sum of $290, as well as to pay restitution as a term of probation in the sum of $180, and to pay reimbursement fees reimbursing the county for the expenses incurred in your behalf in the sum of $675. Now, we've talked about that this 2-year sentence is probated for a period of 5 years, provided you follow all the rules of probation. So let me ask you, do you understand what the rules of probation are?
Yes, Your Honor.
Did you have a chance to go over them in writing and with your attorney?
Yes, Your Honor, I did.
Sorry for asking what seems like a dumb question, but I just need to put it on the record. Are you able to read and write the English language?
Yes, Your Honor.
All right. Then I'm not going to read these rules to you. I want to mention some for emphasis. And let me start out by asking first, can you follow these rules of probation?
Yes, Your Honor.
Will you follow these rules of probation?
I will.
And I ask it that way because if you cannot or will not follow the rules of probation, in all likelihood, you're wasting your time, because if you cannot or will not follow the rules, you're not likely to be allowed to stay on probation. You understand?
Yes, sir.
All right. As I say, I'm not going to read all of these rules to you. We will give you a copy of these rules. You will meet with Mr. Oliver to go over that, and he will begin. Or is he going to meet with you, Mr. Oliver, or with Ms. Duggan?
He will meet with me, Judge, at 3 o'clock this afternoon.
Okay. And that will begin your first conference with your probation officers, your first reporting, and he will provide you with a copy of these rules at that time. And quite frankly, if you want to come by the clerk's office before then, we can get you a copy of those rules and you can take them with you. So I'm not going to read the rules to you, but I want to go over them, some of them for emphasis, and make sure I have all the right information with respect to a couple of the rules. So first of all, first rule that for emphasis is don't break the rules. Don't break the law. You can't expect to stay on probation if you're out there breaking the law. Stay away from from drugs, whether it be drugs or alcohol. Don't go to places where drugs or alcohol are sold, served, or consumed. I will make 3, I hope, common sense exceptions. You can go into a grocery store, you may go into a convenience store, and you can go into a restaurant, even though those places sell alcohol. You just can't purchase or consume or even possess the alcohol from those places or in those places. While on probation, stay away from persons of bad character, persons who've been on probation or who are committing crimes today or in these days. You'll report to the probation officer today, and then on or before the 5th day of each month hereafter while you're on probation. And you'll do that here in Snyder. And that's largely because my understanding is you live here in Snyder. Is that correct?
That's correct, Your Honor.
And what is your residence address?
2602 35th Street, Snyder, Texas.
Right, sir. I'll also tell you that you will continue to live at that address. You will not move to another address unless you get permission from your probation officers. Now, that permission is easily obtained. They're not going to try to keep you from moving. They just want to know where you're going to be living to make sure you're not getting yourself in trouble and it's not putting you in a place where you would likely get in trouble. Next, I've already talked about your financial obligations, fine, restitution, court cost, and reimbursement fees. All of that together totals $2,645. And there will be a $60 per month court supervision fee. And so let me ask you, are you prepared to pay the $2,645 financial obligation in one lump sum payment today, or are you asking permission to pay that out on a monthly basis?
To pay it out on a monthly basis.
And bearing in mind, there is also the $60 per month supervision fee. How much are you asking permission to pay each month to take care of the fine, restitution, court cost reimbursement fees totaling $2,645?
$100. So I guess 40 on that every month, and then the 60 uh court costs or court fees.
The supervision fees.
Yes, yes, sir. Yes, sir. Or would I have to be more than that?
It would take a little bit more than that. Let me see for sure. I did that wrong. It would take $45 per month to pay the $2,645. And actually that would finish a month before your probation was due to expire if you did that, thus making your obligation $105 each month. Is that what you're asking permission to do?
Yes, sir.
Now, let me ask you, do you have the means to earn sufficient funds to not only pay the $105 each month, but also take care of your needs and the needs of any dependents that you might have?
I believe so.
All right, sir. Based on that representation, I accept your request, and I will make those financial obligations, the $45 and the $60, part of your rules. While on probation, you'll observe a curfew. You will not leave this county for more than 3 days without permission from your probation officers. That is up to 3 days. You don't have to have permission to leave the county. If it's going to be longer than that, you have to let them know and obtain their permission. While on probation, you'll have to get a high school diploma or your GED. Do you already have a high school diploma or a GED?
Yes, Your Honor. I have a high school diploma.
Then you will need to furnish a copy of that or proof of that to your probation officer, but that satisfies that obligation. You will perform 160 hours of community service restitution. And the probation office will give you places and suggestions that will allow you to do that. I require a minimum of 10 hours per month until the 160 hours are complete. And then I will require you to appear before me on the 15th day of April for a probation performance review, just to check to see how you're doing. If you're doing well, we will say, good, that's what you're supposed to do. If you're not, we will work with you to try to redirect your efforts, because our effort is to see that you successfully complete this probation. But I'm confident you are aware of this court's reputation well enough to know that while we will do what we can to help you succeed, if necessary, we will redirect your efforts through sanctions short of revoking your probation. And if they are significant enough violations, I don't mean violations, if it's significant enough redirection, including violations of your probation, if after notice to you, after a motion filed, notice to you in a hearing, if it's found that you violated your probation, then ultimately your probation could be revoked and you sent to state jail. Understand that's not our desire. That will not be our efforts. And so I will see you in April, on April 15, to try to make sure you're going in the successful route. I have 2 sessions that day, one at 9:30 and the other at 1:30. I'll give you your choice. Which would you prefer to come to?
9:30.
All right, sir. That will work well, and we'll make that another term of your probation. Now, these are not all of the terms of probation. These are just the ones that I see people violating most often, and so I emphasize them. But I want to give you the chance to ask any question you might have about any of the terms and conditions of probation. And so let me give you that chance. Do you have any question about any of the ones I mentioned or any others that you might, that you already know are part of the rules? Do you have any questions?
No, Your Honor, I don't.
Then those will be the orders of the court. The court's bailiff will come to you in the room you're in, the kiosk with the laptop there, and he will obtain your thumbprint on this judgment, and then we will provide copies to you, and then you will see your probation officer this afternoon at 3, and he will go over these rules with you again. Do you have any other questions before we're in recess?
No, sir, I don't.
All right, we're in recess. Someone will see you in just a few minutes with those copies, Mr. Villarreal. Then you'll be excused until 3 o'clock when you see the probation officer.
Mr. Villarreal,
Yes, sir.
if you could be here about 15 minutes beforehand, that gives you time to fill out a 4-page document that we need. And then we can be able to start right at 3 o'clock.
Yes, sir. I
All right,
will.
thank you, sir.
Thank you.
Thank you.
Okay, well, let's see. Mary Margaret, let me sign off with everybody. Thank you all for your patience in working through this. We're in recess, and have a great week.
Thank you, Judge. Bye, Mary Margaret.
Bye.
See you, Mary
Bye,
Margaret.
Ben.
Bye-bye.
Bye, Ben.
Mary Margaret, I just want to express my appreciation to you for helping us and sticking through this whole morning.
Well, you're quite welcome. I appreciate the call, and I'm sorry it had to be under these circumstances of Terry losing his dad.
For sure. Well, I hope to see you again. I sure don't want to not see you again.
I know it's been too long.
Yes, ma'am. Come see us, and when we can come see people. And as I say, I appreciate your assisting us and your willingness if we were to call on you.
Well, we will. I'll be glad to help y'all anytime I can that you need help.
Okay, thank you,
Mary
Mary Margaret.
Margaret,
Yes.
are you available tomorrow afternoon?
Be careful what you say.
Let me see. I'm thinking I have something, maybe not. Let's see. Yes, I have inauguration day tomorrow. What time?
1:30.
Okay. I can do it.
Is that 10-hour matter we got tomorrow? Kevin?
Oh, I did have something after all.
What do we got tomorrow, Kayla?
Just the 1:30 contested final divorce.
Oh, that's the Baker case that Albra was talking about. You may have
Yeah.
heard her. I don't, it's contested, but I don't think it's going to take that long.
Yeah, she said she had a couple of witnesses
Yeah.
trying to choose which ones.
Yes.
Okay.
Okay. Before you can back out on me, we'll see you at 1:30 tomorrow on Zoom. We'll get you the
Okay,
Zoom information.
I'm putting it in my calendar right now, 1:30.
Okay.
Okay, thanks a lot.
Thank you.
Bye-bye.
Take care of Kenny.
I will. Maybe.
Take some scissors with you.
What for? Oh, to take, if you cut his hair?
Yeah. All right.
I
See
think
you later.
I think it's a COVID hairdo. My son's hair is long too.
All right. See you
All
later. See you
right.
tomorrow.